Welcome to The Deep Dive, the show where we take complex topics, break them down, and give you the essential insights you need to be truly well-informed. Today, we're plunging into a subject that's critical for anyone navigating the legal landscape, especially those gearing up for one of the most challenging exams out there, criminal procedure for the bar exam. Our mission today is really to distill the intricate rules of the Fourth, Fifth, and Sixth Amendments, along with, all those pre-trial, trial, and post-trial considerations. Think of this as your essential roadmap, maybe your shortcut to confidently tackling those essay questions and nailing those multiple choice problems. We want to move beyond just rote memorization to true actionable understanding.
Exactly. We'll be focusing not just on what the rules are, but crucially, the why behind the what and, the critical distinctions that often trip up even seasoned legal minds. Understanding how these constitutional protections interweave and sometimes how they diverge is paramount. We'll try to show you how to dissect a legal problem, apply the correct framework, and then construct an analysis that's crystal clear, precise. This isn't just about passing an exam. It's really about building a robust legal mind, capable of navigating complex scenarios.
All right, let's dive straight into the Fourth Amendment. This is truly the gateway to understanding what constitutes an unreasonable search or seizure. We're starting with the general principles, and the first big one we absolutely need to talk about is standing. This is foundational for any Fourth Amendment analysis you're going to do.
It truly is. When we talk about standing in, the Fourth Amendment context, it's not just about whether evidence was unlawfully obtained by the police. It's about who gets to complain about that violation. A defendant must have standing to assert a Fourth Amendment violation. This means their own personal constitutional rights must have been infringed upon. It's not enough that the police did something wrong in a general sense. They must have done something wrong to the defendant themselves.
So it's intensely personal then. It's like, was your personal space invaded? Was your privacy violated? Was your freedom restrained? How do you actually prove that specific personal infringement to establish standing?
Well, you need proof that the defendant himself was seized, or that they had a reasonable expectation of privacy regarding the specific place searched, or the particular item seized. And this is absolutely critical for the bar exam because you'll frequently see fact patterns designed to trick you on this. For example, watch out for scenarios where incriminating evidence is seized at, say, another person's home. If the defendant was just a guest there, maybe with no real expectation of privacy in that specific area or item, well, the government's action might be valid even if it was arguably a violation of the homeowner's rights. The focus, like I said, is acutely on the individual's personal rights. It forces you to ask, is the government action against this specific defendant or against someone else? That often determines if a defendant can even bring the claim.
Right. That distinction is incredibly important. You can't complain about a violation of someone else's rights, only your own. So, once we've established standing, we move to what many consider the hammer of the Fourth Amendment. The exclusionary rule. Everyone talks about it. It's famous from TV. But what's its core purpose? And maybe more importantly for you listening, what are its many, many exceptions?
Yeah, the core purpose of the exclusionary rule is quite specific. It prevents the introduction of unlawfully seized evidence at a trial against the defendant. It's a judge-made rule established by the Supreme Court, and its primary goal is really to deter police misconduct. It's crucial to remember that it's not considered a personal right of the defendant, like, say, the right to remain silent. It's more of a prophylactic measure, a tool to discourage future constitutional violations by law enforcement. The Supreme Court's reasoning is basically, if police can't use the evidence they obtained illegally, they'll be less likely to engage in illegal conduct in the future.
Okay, and for anyone preparing for the bar, this is precisely where you need to be sharp because the rule has a lot of crucial exceptions. Missing just one of these could entirely change the outcome of a hypothetical on an essay or, a multiple choice question. So when does this hammer not fall?
Absolutely. The rule does not apply in several key circumstances. For example, it doesn't apply in federal habeas corpus review, which is a post-conviction challenge. It also doesn't apply in grand jury proceedings. So grand juries can consider illegally obtained evidence when deciding whether to indict someone. The same goes for preliminary proceedings like probable cause hearings, bail proceedings, sentencing proceedings, or proceedings to revoke parole. So its scope is pretty much limited to the trial itself, specifically the prosecution's case in chief.
So if police illegally obtain evidence, it can still pop up in some buckets of the legal process, just not necessarily to prove guilt at the main trial. But you mentioned another high-yield detail, the impeachment exception. That seems like a powerful tool for the prosecution, doesn't it?
It is. This is a vital distinction. Unlawfully seized evidence can be used to impeach the defendant's testimony if they choose to take the stand and lie. Imagine police illegally search a defendant's car, find a diary admitting guilt. That diary can't be used to prove guilt in the prosecution's main case, but if the defendant gets on the stand and says, "I was never in that car," the prosecutor could potentially use that illegally obtained diary entry to show the defendant is lying, to discredit their testimony. The rationale here is that the integrity of the judicial process, specifically preventing perjury, is seen as outweighing the deterrence goal of the exclusionary rule in this very specific context. And remember, it also doesn't apply in civil proceedings.
That impeachment point is huge for a bar exam. It really highlights the nuanced application of these rules. Okay, procedurally, who makes the call on whether evidence should be suppressed?
That's the judge. It's usually handled through a pretrial motion to suppress evidence. And on appeal, the judge's findings of fact are reviewed for clear error. This means there's a very high deference to the trial judge's findings because, they were there, they saw the witnesses, assessed credibility. So if the judge decided an officer was telling the truth about what they saw, an appeals court would be very, very hesitant to overturn that factual finding. However, findings of law are reviewed de novo, meaning from new. The appellate court gives no deference at all to the trial judge's legal conclusions and reviews them fresh.
That clarifies the different levels of scrutiny on appeal. Good. And one final general principle before we move on to specifics, the concept of government conduct.
Right.
When does the Fourth Amendment even apply? Is it whenever incriminating evidence is found?
No, absolutely not. Evidence will be excluded on the Fourth Amendment only if it was discovered by a government actor. This is a critical threshold requirement. The Fourth Amendment is a check on government power, not private actions. So who qualifies as a government actor? Well, obviously publicly funded police. But it also extends to private persons directed by the police to perform a search, or deputized private police, maybe like security guards with full police powers in some cases. The implication here is significant. If a purely private individual or entity with zero government involvement obtains incriminating evidence, maybe by illegally breaking into someone's house and finding something, the Fourth Amendment typically doesn't apply. That evidence can be admissible, believe it or not, even if the private individual's actions were themselves illegal. It's all about whether there was state action.
All right, let's transition from those foundational Fourth Amendment principles to the first major application. Arrests, which the Fourth Amendment views as an unreasonable seizure of persons. When is your freedom actually restrained by the police in a way that triggers Fourth Amendment scrutiny?
Well, a Fourth Amendment seizure of a person occurs when police, by means of physical force or a show of authority, intend to terminate or restrain a person's freedom of movement. That's the core definition. Think about it. If an officer yells, "Stop," and points a gun, that's a pretty clear show of authority intending to restrain. However, sometimes the police's intent to restrain is ambiguous, or maybe the defendant passively submitted without clear physical force being used. In those cases, a seizure occurs only if a reasonable innocent person would not feel free to leave under the totality of the circumstances. And this is an objective test. It doesn't matter what the officer subjectively intended, or if the defendant felt guilty and thus felt compelled to stay. It's about what a hypothetical, reasonable innocent person would perceive in that situation.
That reasonable innocent person standard is a great mental tool for analyzing these scenarios. It shifts the focus away from subjective intentions. And speaking of brief restraints, that brings us to stop and frisk, or Terry stops. We see these portrayed all the time, often controversially. What's the distinction here between a stop and a frisk?
Okay, so a stop is a temporary investigative detention. It constitutes a Fourth Amendment seizure if an officer, by means of physical force or a show of authority, like an order to stop, has restrained a person's liberty. This type of stop is justified by reasonable suspicion based on articulable facts of illegal activity. This is less than probable cause, but definitely more than just a gut feeling or a hunch. The officer needs specific, objective facts they can point to that suggest criminal activity might be happening, like seeing someone nervously peering into cars late at night in a high-theft area might create reasonable suspicion.
So the officer can't just stop anyone. They need some concrete, observable facts.
Okay.
Then there's the frisk, the pat-down. What justifies that second step?
The frisk is a separate step. An officer may pat down a person's outer clothing if the officer has reasonable suspicion that the person was or is involved in criminal activity, and this is key, that the frisk is necessary for safety. This is fundamentally about officer safety and searching for weapons. It's not a search for general evidence of a crime. It's a limited search for weapons that could pose a danger to the officer or others nearby.
But there's a critical extension to the frisk, isn't there? The plain feel exception. This sounds like it could be tricky in practice.
You're right. It's often a point of contention and a common bar exam question. If an officer conducting a valid frisk feels an object whose identity is immediately obvious, meaning the officer, based on their experience, has probable cause to believe that the object is contraband just from its feel, then that object can be seized. The key here is immediately obvious. There's absolutely no further manipulation allowed. No squeezing, no prodding, no shifting the object around to try and figure out what it is. If it's not immediately apparent just by the initial touch, they can't seize it, and any further exploration would likely make the seizure invalid. For instance, feeling the distinct outline of a handgun. Probably immediately obvious. Feeling a small squishy bag and needing to manipulate it to guess if it's drugs. That's not immediately obvious.
Okay, so the officer can't go on a fishing expedition under the guise of a frisk. And what about the limitations on these Terry stops? They can't just last forever, can they?
Precisely. An officer must use the least intrusive means reasonably available to verify or dispel the officer's suspicion in a short time. The idea is to quickly confirm or deny the reasonable suspicion. It's meant to be brief. However, if that reasonable suspicion grows into probable cause during the stop, maybe the person admits to something, or more evidence becomes apparent, then the officer can make an arrest and conduct a full search incident to arrest, moving beyond the limited scope of a Terry frisk. The initial stop provides a lawful basis for further investigation that might escalate.
Okay, from brief stops, let's move to warrants. These are generally the preferred method for arrests and searches under the Fourth Amendment. Right. Reflects that ideal of judicial oversight. First, arrest warrants.
Right. Arrest warrants are issued by a detached, neutral magistrate, a judge upon a finding of probable cause. This probable cause must establish two things. One, that a crime was committed, and two, that the person identified was involved. The warrant itself must describe with particularity both the defendant and the crime. However, a crucial nuance for the bar exam. A deficient warrant does not automatically invalidate an arrest made pursuant to it if probable cause actually existed, particularly if the arrest is made in a public place. Why? Because a warrant generally isn't required for a proper arrest based on probable cause in a public place anyway. The warrant is preferred, but it's not always an absolute necessity for the arrest itself in public.
That's a subtle but important point for everyone listening to remember. The warrant is preferred, but probable cause is paramount, especially in a public setting. What about search warrants? Those seem to carry more weight, usually.
Yeah, search warrants are also issued by a detached, neutral magistrate upon a finding of probable cause, which here means a reasonable belief that contraband or evidence of a crime will be found in a particular place. These warrants must be supported by oath or affidavit, meaning the officer provides sworn information, usually in writing, and they must describe with particularity the places to be searched and the items to be seized. This specificity prevents general exploratory rummaging by the police. The sources of probable cause can be varied. An officer's own personal observations, information obtained from a reliable known informant, or maybe information from an unknown informant that's been verified or corroborated somehow, or even evidence lawfully seized during a stop based on reasonable suspicion, or during a consensual search, or discovered in plain view. It's about a reasonable belief based on concrete facts presented to the magistrate.
So probable cause isn't just a hunch. It needs a concrete, articulable basis that a neutral judge can actually review. And there's also the knock and announce rule for executing warrants, right? This often leads to confusion.
Yes. Generally, police must announce their presence and purpose when executing a warrant. Unless there are exigent circumstances like a reasonable fear, evidence will be destroyed or it would endanger the officers, or state law allows an exception. Crucially, however, and this is a frequent point of confusion for students and a common bar exam trick, a failure to knock and announce does not trigger the exclusionary rule. It's a procedural violation, sure, but it typically doesn't lead to the suppression of the evidence found during the subsequent search. The Supreme Court views the knock and announce rule as protecting privacy and preventing property damage, not as a core Fourth Amendment interest that warrants excluding the evidence itself.
That's a classic bar exam trap right there, understanding when the exclusionary rule applies versus when it doesn't, even for what seems like a clear police error. Now, we've mentioned probable cause and reasonable suspicion several times, along with beyond a reasonable doubt. These are the three key criminal standards you absolutely need to know cold. Let's lay those out clearly, maybe from highest certainty down.
Indeed. We have three main standards, kind of a sliding scale of certainty. First, at the top, beyond a reasonable doubt. This is a firm belief in the defendant's guilt. This is the highest standard required for conviction in a criminal trial, reflecting the seriousness of depriving someone of liberty. Second, probable cause. This is a reasonable belief that a crime was committed or evidence will be found. This is the standard for getting arrest and search warrants. It's a practical, common-sense standard, doesn't require proof beyond a reasonable doubt, but definitely more than a mere hunch. And finally, at the bottom, reasonable suspicion. This is a reasonable basis for suspecting criminal activity. This is the lowest standard, justifying those Terry stops and frisks. It's based on specific articulable facts, but doesn't rise to the level of probable cause. Understanding where each standard applies is just vital for any criminal procedure question you encounter.
That clarifies the different levels of suspicion needed perfectly. And what about warrantless arrests? When can police just act on the spot without that piece of paper from a judge?
Well, first, remember that an invalid arrest alone is not a defense to the crime charged. So if you're illegally arrested, but there's still valid independent evidence, you can still be prosecuted. However, an invalid arrest will affect the admissibility of evidence seized pursuant to that arrest. As for when no warrant is needed, an arrest warrant is not needed when the arrest is made in a public place, meaning if probable cause exists, police can arrest you in public without needing a warrant first, or when the arrestee committed a crime in the arresting party's presence, whether that's a felony or a misdemeanor. For any warrantless arrest, the core question is whether an officer could conclude, considering all of the surrounding circumstances, that there is a substantial chance that criminal activity occurred. This is a practical, flexible standard that allows police to react to events as they unfold.
All right, we've covered the general principles of the Fourth Amendment and how it applies to arrests. Now let's get into search and seizure, specifically protecting your stuff and your space. How do we actually define a Fourth Amendment search? What triggers that constitutional protection?
Yeah, this is a constantly evolving area of law, really. A search is considered unreasonable if the government invades a place protected by a reasonable expectation of privacy, or if it physically intrudes upon a constitutionally protected area to gather information. This covers both the cat's line of cases, focusing on that reasonable expectation of privacy, the idea that the Fourth Amendment protects people, not places, and the more recent Jones line of cases, which re-emphasize that a physical trespass onto a constitutionally protected area, like your house or your car, with the intent to gather information is also a search, regardless of whether a privacy expectation was violated in the cat sense.
So it could be either violating your privacy expectation or physically trespassing to get info. Okay.
Exactly. For instance, cats involved listening devices on a public phone booth. The court said Katz had a reasonable expectation of privacy in his conversation even there. Jones involved attaching a GPS device to a car, and the court found that physical trespass onto the vehicle to gather information was a search.
Okay, so it's not just about physical intrusion. It can be about your expectation of privacy in certain information or places or physical trespass. Let's go through some common search scenarios. What areas generally have a high expectation of privacy and what doesn't? Especially those classic bar exam distinctions.
Generally, areas like your home, private room, or office are constitutionally protected and carry a high expectation of privacy. Warrants are strongly preferred here. A specific detail that often comes up: the use of a drug-sniffing dog is a search if it physically intrudes onto constitutionally protected property. For instance, the curtilage of a home, like bringing the dog up onto your porch to sniff at the door. That's a search. For luggage, there's a reasonable expectation of privacy for invasive searches. Police generally need a warrant to open your closed suitcase, but not for canine sniffs of the exterior of the luggage in a public place, unless that sniff itself constitutes a physical intrusion onto constitutionally protected property.
And what about automobiles? Those are a frequent source of Fourth Amendment issues, right? All those traffic stops.
Definitely. Stopping a vehicle, even for a routine traffic violation like speeding, requires reasonable suspicion of a legal violation. However, probable cause is needed for a pretextual stop arising from a traffic violation to investigate a different legal violation. This means if an officer pulls you over for a broken taillight, but their real purpose is to search for drugs based on a hunch, they still need probable cause to search for those drugs, not just reasonable suspicion for the taillight. The reason for the stop doesn't automatically justify a full search. Interestingly, no reasonable suspicion is required for a valid checkpoint, such as DUI checkpoints or immigration checkpoints near borders. These are generally upheld as serving a valid public interest that outweighs the minimal intrusion, as long as they're conducted in a neutral, non-discriminatory way, stopping cars randomly or based on a fixed pattern.
So you can be stopped at a checkpoint without any individual suspicion.
Sure.
Okay, now what are some common areas where generally there's no reasonable expectation of privacy? These are frequent targets for bar exam questions because they seem intuitive but aren't legally protected.
Yeah, these are often called non-protected areas. They include abandoned property. Once you abandon something, like throwing trash out on the curb, you lose your privacy interest in it. The open fields doctrine means there's no privacy expectation in large undeveloped areas, even if they're technically private property and maybe even fenced. Think fields, woods, away from the house itself. And the odor from a car, meaning smelling the air outside the car, like smelling marijuana wafting from a window, does not constitute a search because it's considered to be in plain view or plain smell. The police are just using their natural senses in a public space.
That makes sense. If you've abandoned something, you've given up your privacy interests. And what about technology? This is an incredibly dynamic area, constantly pushed by new inventions.
It definitely is. The Supreme Court is continuously grappling with how these old principles apply to new tech. For example, attaching a tracking device to a person without consent or physically intruding on a suspect's property to install one is a search. That goes back to the Jones physical trespass idea. Likewise, collecting cell site location information from a wireless carrier is a search, end quote, even though you voluntarily share that data with your provider. The aggregation of that data over time creates a significant privacy interest, according to the court in Carpenter. And using sense-enhancing devices that are not used by the general public is a search, like using thermal imagers to scan a home for heat signatures indicating marijuana grow lights, as seen in Kylo. These cases really push the boundaries of what counts as a search and highlight that tension between law enforcement needs and individual privacy in our digital age.
Okay, let's unpack this with our handy mnemonic for the exceptions to the search warrant requirement. Sad spaces. These are the key situations where police don't necessarily need a warrant to conduct a search, but remember, their actions still must be reasonable under the Fourth Amendment. First up, S, for search incident to a lawful arrest.
Right. No warrant is required for this type of search, so long as the search is reasonable in scope and contemporaneous, with meeting happening around the same time as the arrest. This exception is justified mainly by two reasons: officer safety, searching for weapons the arrestee might use, and preventing the destruction or concealment of evidence related to the crime of arrest. This allows for a wingspan search, which covers the arrestee's person and the immediate surrounding area, basically, whatever is within the arrestee's immediate control or reach. This includes pockets and containers on their person. However, a huge point, this does not automatically include searching the contents of cell phones or laptops found on the arrestee unless specific exigent circumstances exist. The Supreme Court in Riley recognized a much higher privacy interest in digital data.
So, officers can't just dive into your phone after an arrest without another distinct justification, like a separate warrant or maybe consent. That's a major protection. What about searching a home or a vehicle incident to arrest? These seem like potentially broader powers.
For a home, if an arrest happens inside, police can conduct a protective sweep. This is permissible, even without probable cause or reasonable suspicion for the sweep itself. But it's a quick and limited search, confined to places in the home immediately adjoining the place of arrest from which an attack could be launched and in which a person might be hiding. Think closets or adjacent rooms. It can be broadened beyond those adjacent areas only if there is a reasonable suspicion that Confederates might be hiding elsewhere in the house. For vehicles, a search incident to arrest is permitted only if 1. The arrestee is unsecured and within reaching distance of a passenger compartment and could potentially reach possible weapons or evidence during the search, or 2. It is reasonable to believe that evidence of the offense of arrest might be in the vehicle. That second prong is key. The evidence must relate to the reason for the arrest. And finally, inventory searches can be conducted without a warrant when police arrest a driver and lawfully impound the car. These are supposed to be administrative, following standard procedures, like cataloging contents to protect the police from claims of theft or loss, and to ensure public safety from dangerous items, not primarily for finding criminal evidence.
Okay, next up in sad spaces is A, for administrative searches. These aren't typically about finding evidence of a crime, are they? They seem to serve a different purpose altogether.
Exactly. These searches serve some kind of regulatory or public safety purpose, not primarily criminal law enforcement. Generally, a warrant is required for non-consensual fire, health, or safety inspections of residential or private commercial property. The Supreme Court says you still have a privacy interest in your home or business, even for these routine inspections. However, a warrant is not required for searches used to ensure compliance with administrative regulations in certain specific contexts. Examples include searches of students by public school officials, justified by the need for school safety, businesses in closely regulated